document that recommended you for appointment as the Chief Justice of Nigeria. I'm fanatically attached to use of words. When you look at the recital and the contributions of all the justices in that meeting, your qualification was what stood you out against two other colleagues of yours. And I do know that constitutionally, appointment into judicial offices are based strictly on seniority, of which gave you an age. But you see in the document, the recommendation was that you are a preferred candidate. My thinking will have been that the document should say you are the most qualified, which is the norm, but it's okay. My major concern, sir, is this. Like my colleague have said, there are really growing concerns about appointment of judicial officers in this country. There are really concerns. And you know, having traveled this long, you know what it used to be and what it is now. If confirmed as the Chief Justice of Nigeria, what will you do, differently to ensure that we reverse back to that era where integrity, honesty, commitment to professionalism, and respect for the institution of judiciary are the sine qua non for qualification for appointment into these offices? That's the question. Thank you, sir.
The Deputy Senate President, Senator Moagege, started from what he decided not to call petitions, even though many papers and the press that accosted me on the day I was sworn in as acting said justices of the Supreme Court wrote petition. We did not write petition. It was an internal memo of, not of the court, even, but of justices. There were 15 justices of the Supreme Court then, with the Chief Justice. And we had either individually, as friends, as colleagues, or in group at meetings, raised certain issues that were touching on persons' working conditions of justices, such as some of us not having accommodation at all, particularly amongst my brothers who were appointed in 2020. Some have still not gotten accommodation. Now ask me, where do they live? Some live very far away, and that was why on Monday when we were to sit, we had to wait for a colleague who stayed quite far to the court. Then some vehicles have not been provided. Our entitlement as justices of Supreme Court to attend workshops were claimed not to be provided for, whereas in the budget there were these provisions. When we realized that each time we had a meeting and we took this up, our brother, the Honorable the Chief Justice, then probably forgot or didn't remember to take care of it. Sometimes the management of the court will still tell the Chief Justice there was no money. So we sat together and put something in paper. No secretary typed this. One of us who was secretary to a committee, which was then the welfare committee of the court, typed it, and we all sat and signed, the 14 of us, and after signing this memo, we took it up to deliver it personally to our brother, the Chief Justice. We didn't allow anybody to see this memo. How it came on pages of newspaper is still a miracle to us. We wouldn't know, because we never made it available. In fact, no justice had copy of this memo. We just read it to ourselves, and we agreed, and we signed and took it to our brother. So I got on the newspapers, if you like, got leaked to the press. We were embarrassed ourselves, and we all met with the Chief Justice again to say, what happened? We wanted His Lordship to get the management of the court to meet with us so that we could let them know we had no problem with our number one. We agreed. The Chief Justice gave us a time, and we all gathered again in the chambers of the Chief Justice conference room, only to realize that there was no plan to bring any member of the management. The Chief Justice himself was surprised that we were around again. His Lordship probably forgot. In fact, he said so. He apologized that he forgot to invite them, and we left. So there was no petition either to or against the Chief Justice. We remained brothers, and we were acting as one, even though we had our complaints, like the distinguished senator said, you know, when there was a circular that moved around that, you know, the generator will be switched off at 4 o'clock, when sometimes we may be sitting in court till 6. And I had to climb up the staircase when I arrived the court before 8 a.m. because the circular said generator won't be switched on until 8 a.m. So any justice that came before 8 must either have to stay there if he cannot climb, or climb the stairs to the second to the third floors. We felt that was embarrassing enough. We told our brother, the Chief Justice, and nothing was done to it. I mean, he said he didn't know, you know, what was happening. That was exactly what happened. It was not a petition. The justices were not protesting. You know, no, it was not a protest. We couldn't have carried placards. You know, we just thought to put our complaint on paper for our brother, the Chief Justice. That was all. As to Ariwoola's fission, I haven't gone through all the courts, all the hierarchy of courts, and I haven't stayed this far. This is my 11th year in the Supreme Court. I know that judiciary, even though said to be the third arm of government, cannot work alone as an independent arm of government. The Supreme Court, or the judiciary, if you like, needs the other two arms of government, mostly. Particularly, this Honorable Senate, in that the judiciary of Nigeria is suffering of lack of funds. We're trying to introduce technology. This has gone far in other climes. Technology is so germane, it's so important that it is my desire to introduce like e-filing and electronic service of processes. By October, when we are doing our legal year, work has gone very far. The Supreme Court will start off in the way we have computerized and introduced in one of the 3 courts in the court. Great technology that lawyers may soon address the court from the comfort of their chambers once they are properly briefed. Like many of us will have had Zoom meetings, Zoom consultation with our friends, our doctors, and so on, from far away in foreign lands. We are starting that soon. What has been our problem is fund. And I believe and happy that if this Honorable Senate is aware that we need to move forward, we need to advance, we need fund so to do. So by the time our budget is presented, we believe it will pass through. There's need to improve on the way we file processes, the way we still do a lot of writing, despite the brief writing of counsel in respect of matters. Justices still record in longhand. But this will change this time around because we are engaging stenographers that will have knowledge, great knowledge of technical terms, legal terms, because I've discovered that some of those engaged will misunderstand what counsel say in their address or in their brief. So we're engaging stenographers, and we're going to do transcriptions of, submissions, addresses. We've been doing front loading of pleadings. We shall soon go on front loading evidence, front loading exhibits, so that counsel may not need to come to court. We've always said it, people come from far away, Maiduguri, from far down Port Harcourt, and they get to court only to discover that the court is not sitting. That is not too good. So, it is my desire to plead with this Honorable Senate to approve our budget to do this, because it will affect every one of us. I believe that's why we have checks and balances. The judiciary cannot operate without the Senate, nor without the executive arm of government. Indeed, that's what has brought us all here today. The judicial arm of government having played its role by nominating and recommending, the executive having made its choice by appointing. It is required that the Senate must confirm. Otherwise, the nominee of the president will be sent back to him. But we shall make progress at the next stage of the judiciary of this country. On the rules of court, it must have been read in our memo that for over 3 years, rules of court were prepared, and we haven't seen, it hasn't seen light of day. Because this is just the Supreme Court. And there are other courts in the judiciary of this nation. But we want to, in the Supreme Court, give the lead, amend our rules and procedure so that we'll move from the archaic procedure that we've always engaged. So that, you know, businessmen, investors, we know that the courts are functioning and they are being effective, not just giving judgments, but we are doing effective services. That's why we're going to amend the rules appropriately. We're going to meet with all the heads of courts. Aside from the state high courts, in the past we used to have common rules of court. But each court is entitled to have its own rules of procedure, which will enable the courts function effectively. We have set the machinery in motion. And as to how we go about it, the following week, barely 5 days after I was sworn in acting capacity, I had met with my brother justices of the Supreme Court, and we agreed and set up 4 committees. We were left with 13 of us. The 12th, to which I am the 13th, were set up into 3-man committee each. The number 2 in the court heads the Committee on Finance and Accounts. The next to head litigation and head. The next to head administration and library. And another committee for the welfare of the justices and staff of the court. These committees have set in motion since July, before we went on vacation. And things have begun to give a different look. That's why some of us are still on their workshop now in Dubai to learn more about, you know, administration of justice, because knowledge is germane. You learn every day. You learn every day. So, because, you know, in fact, the Committee on Finance and Accounts had to meet with those in charge of accounts few days ago. I believe because a tree does not make forest. If the Chief Justice insists on knowing everything, calling on the management, that is how they get misled. So, these different committees of 3, which make up with the 12 justices there, have been working very hard. And we have started making progress. We just came back only on the 12th of September. Most of us couldn't go on vacation because it is our court. We told the management, it is our court. All in the management staff are to assist us to do our best to give justice to this country. So we have been working very hard to ensure that such things that happened that made us to have to now write to our brother justice, the Chief Justice, would not occur again. There will be nothing like you know, protesting or complaint when all the justices are involved in the administration of the court. Like Senator Bamidele Opeyemi said, on the appointment of judicial officers. Appointment of judicial officers is provided for in the Constitution. to be appointed to the High Court judge, the Constitution says you must be 10 years in practice. To go to Court of Appeal, 12 years. And to be a Justice of Supreme Court, 15 years. That is what most people think is all about. And, so they aspire. But I'm happy that the National Judicial Council plays a great role in appointment of judicial officers in this country. The state will sit, propose, recommend. These ones will be subjected to interview. You must be in active practice. And I've always told some of our people, you must search yourself, know your worth. To be a judicial officer, it's not a, I beg your pardon, palongo. It's not a dance that you can learn on the way. You've got to know yourself, know your worth. That's why we should play to ourselves, to ask whoever is our nominee, can you do this job? And that's why most often, and in some states, we are said to be only seen and not heard. We cannot be heard to complain. We keep quiet often, and we are denied of our entitlements because we cannot be heard or be seen to complain. Maybe nobody may have even heard of our complaint if our memo had not been leaked to the press. And then we are called names, justices dancing nakedly in the market square. I mean, that was insulting to the least. So, I want to plead again, Your Excellency, the President of the Senate and distinguished senators, that when we have our budget presented, please look into it. And that's why we've said, and we are doing that, justices must participate in the preparation and defending of our budget. I mean, I'm seeing my brothers, all of you, will not see me seated to come and defend our budget. We are not to speak, but the admin people, yes, will bring it up there. And we look and we have, greeted. What are we doing here? Is our budget. We are not to be doing that. There's so much work in the court. So, we shall make progress, once we have enough fund so to do. And it is my desire to meet with the President, who has presented my name, that I'm his choice, to say the only way we can move is for us to have fund. The judiciary of Nigeria must be properly funded. Judges should not be seen to go cap in hand. No. We should not beg for our entitlement. We should not. We have too much to do than to go about begging. And I'm sure you are aware, he who goes a begging are sorrowing. May we not go a sorrowing. So, that much with the appointment of judicial officers. We are supposed to be constitutionally 21 justices. But we are 13 now. We just discovered on Monday when we started sitting, that 12 appeals were listed for justices to deal with. 12 appeals on one day. So in 3 days, you can imagine how many appeals we would take. And how do we write these judgments? We need to appoint more justices. But as we said, the rules will have to be amended. There are many cases that should not be allowed to come up. Many cases should be allowed to stop at the Court of Appeal. It's only by the constitutional amendment that that can happen. And the Constitution can only be amended not by the courts, but by this distinguished House, Senate. National Assembly should please help us, the country, help the nation. Amending this one must end here. And once you say so, that is the law. That is the law. It becomes the law. I believe with the Senate President and the distinguished senators, we shall make progress on that. Senator Suswan.
Distinguished colleagues, Lord, we have asked him questions and he's responding to those questions. And the questions, just hold on please. The questions we asked were the first round of questions. It's an opportunity for us to know, to understand. And it's also an opportunity for him and the judiciary to enlighten the entire country. So please, let's allow him to respond to these questions, and then let's see how the next set will look like. Thank you.
If justice is delayed, it will end up denying justice. But as the saying goes, if you rush justice, you end up denying justice. How? If a suspect gets into the dock to be tried, and he says, please, my Lord, my key witness is not available. Give me an adjournment. And you said, no, you have to close your case. That is rushing justice, and you have denied him justice. But with the administration of criminal justice reformed that is now in practice, there are a number of adjournments that the court must take. There are a number of days a matter must be dealt with. Just like in some political cases, there is provision that a matter must be heard and concluded within a certain time. And if you are aggrieved, you want to appeal, your appeal once filed must be disposed of within a certain time. If you have complaint you want to file, you must file within 14 days. The filing, as I've always said, when laws are made, it is what the court says the law is, that is the law. Otherwise, it remains lifeless in the law books. So, that 14 days, people miscount it. 14 days starts not like you count money. It starts from the date, that's what the law says, from the date of the occurrence of that event you are complaining about. So many people have filed processes on the 15th day, when the law talks about 14 days. You start counting from the following day, which is the practice. But that law says from the day of the occurrence of that event. If you are challenging the presentation or the declaration of a different person from you who won the primary, the day is the day of the announcement. 14 days begins to run from that day. And then to 14 days. If you file within 14 days, the court must dispose of the matter within 180 days. Not 1 day after 180 days. People had challenged filing or tendering of documents up to Supreme Court, and by the time they had gone back, because 180 days continued to run after them, to Court of Appeal, to Supreme Court. By the time they go back to the trial court, the trial judge says, sorry, I can no longer entertain your matter. What do you mean? It is 180 days. Statutory limitation. Then the Court of Appeal within 60 days. The Supreme Court within 60 days. Particularly the Supreme Court, which is the final court, which is the apex court, cannot go beyond that date also. So, yes, justice delayed is justice denied. But you can be sure that even though the wheel of justice may be sluggish, may move sluggishly, but it's only slow, not sluggish. But you can be sure that it is steady. Because if you rush it, you will end up denying justice. And of course, when justice is denied, you may not feel it until you are denied of justice. That's when you feel it. So we are familiar with that, and we're going to, a meeting is being proposed with heads of various courts so that they will be taken along. You know, we won't run the Supreme Court alone. I've been having the maximum cooperation of my brother justices of the Supreme Court, and I'm quite happy about that. Distinguished senators, you can see. The only ones that are not here, as I said, you know, are for a workshop in Dubai. All my brother justices here, they know we are running the system together. It is not a court of Chief Justice. It is a Supreme Court that we are all serving. And we must not fail. Thank you very much. Yes, Senator.
Please, distinguished colleagues, if it is the view of the majority of our colleagues here that the nominee, my Lord, takes a bow and go, I will rule so. Even if I have a different opinion. Because for me, it would have been an opportunity for us to learn and for Nigerians to also understand. But just hold on, just hold on. But this is, please, this is the home of democracy. This is the home of democracy. And in democracy, the majority rules. So is it the opinion of this Senate that my Lord, the nominee, takes a bow and go, having responded very well to all the questions raised so far? Is it the view of this Senate that he takes a bow? Yes. My Lord, Distinguished colleagues. Distinguished colleagues, please. Oh dear. Chief Whip, please let them sit down, please. Oh my God. Distinguished colleagues, please let's sit down.